Hi, this phone call is being recorded.
Okay. Hey, hold on. I'm gonna do the same too.
This call is being recorded.
Okay. Hey, Sean, it's Joe.
Hey, how you doing?
So listen, I just wanted to talk one time. I mean, I guess if we're parting ways, I just want to make sure that we're on the same page, and I kind of wanted to explain a little about my thought process on the motion to suppress.
Okay, go ahead.
All right. So I understand that your contention is, and I believe you because I've seen the video, and I don't think you committed a crime. But your contention is that Daley lied, and that he took your phone. He knew that it was.
No, he took my son's phone.
He knew it was your.
He didn't take my phone, sir. He took my son's phone. There's a big difference there.
I know. He took a phone. He says it's your phone. It's your son's phone. I know. I've seen the videos that your son goes to the station and says it's his phone. I know that there's a return of property motion. I know that. Those are all things that are for trial because the challenging of the search and seizure of the phone. You're talking about the seizure of the phone. We argued that the lies. That's what the motion for Frank's hearing is for.
We didn't argue that, sir. We did not argue that in Frank's motion. Your argument was where the phone landed, which was irrelevant to the points of issue. You did not mention one fact about that in the Frank's hearing. I have it. I'm going to be getting I will be requesting a transcript of that as well. You did not mention anything about the probative relevant factors and points of issue.
Well, we didn't get the Frank's hearing, though. We don't automatically get a Frank's hearing. We make a request for a Frank's hearing. The judge denied the Frank's hearing altogether. So we've preserved that issue. We've preserved it. We put it in the motion. The judge denied it. But that's an issue that remains viable if you were convicted. I don't think you're going to be convicted. But if you're convicted, you've already preserved that right. It's already there. It's part of the, it's available for appellate review if you were convicted. It's not part of the motion to suppress, though. Motion to suppress is limited in scope to what the police officers claimed, because they're the ones that are going to be testifying. It's going to be Daley and the other guy, can't think of his name at the moment, but it's going to be those guys that are testifying. It's a different tack. It's not the same thing. And relatedly, I know you said it shouldn't go to trial. I think if it goes to trial, that all those lies are going to be exposed, and you don't want to keep hammering it because the Commonwealth is going to try to, prepare for it, twist it around. If you show your whole hand and then you fail, you've already exposed what you're going to argue at trial. Whereas there's some value in not just shooting your shot, so to speak, beforehand when there's no chance of success in this motion to suppress. I really don't think there is. I filed it because you asked me to. I don't think there's a chance of success. I do think there's a good chance at trial, and we've already gotten the dismissal of the most serious charge. So I just wanted to give you my thought process on that, and I'm not engaged in some conspiracy. I'm calling you, I'm responding to you. I was out for a couple of weeks, and, I just don't want to end on a bad footing with you because I value trying to treat people with respect, and I didn't want to end on bad terms.
Okay, but this is what happened. He said I wasn't be detained. He left. He came back to further intimidate me. I said, pervert. He got out of his car and arrested me. That's First Amendment. That's in violations of Title 18, 241 and 242. I was arrested.
And those are claims that you could make. You could file those after you win this case. You could file those claims against them, but it's separate from this case.
It doesn't make any sense to me. It doesn't make any sense that an officer is allowed to illegally. This is illegal. It doesn't make any sense. How can that even be relevant evidence if he used illegal methods to seize the phone?
Well, that's what we argued in the Frank's motion, the requested Frank's motion. So, yes, that's a good argument. That's an argument that you would have for appeal if you lose, because I think the judge was wrong in not. We did. We put him on notice. We put in the affidavit for the Frank's hearing. We did talk about the fact that it was your son's phone. We did talk about that. We did, and we didn't. We got denied to have the hearing, so we didn't even get to have the hearing. It was denied without a hearing. So that's still I agree with you, Sean. And that's a defense that we would use at trial. We would show the jury that these officers are lying, that what they're saying just isn't true in comparison to the video evidence, that you didn't commit any crimes. I feel very strongly about that.
You've seen the whole video, right?
Yeah, I've seen it multiple times. I've seen all the videos that you've sent. I've seen the one with you outside of your home and the officer came and first responded. I saw the ones with your son talking to the police on the phone, going into the police station, and the response from the officers. Yes, I've seen many videos.
Okay, did you see...
I feel that you didn't commit a crime. I think you were probably pissed them off or whatever, but that's not a crime. I don't think you committed a crime in those videos.
Did you see the Commonwealth's illegally obtained video evidence?
They have provided. Isn't it the same as yours? Isn't it the same that you provided me? The longest video.
I'm not sure, but did you view their video evidence?
I have viewed. Hold on, I'm just trying to see if they. Yeah, video from ADA. Yeah, it's the same video that you provided.
Okay, now is
25-minute long video.
Now you can see that it's not illegal to swear at the police, and you can see that I'm exercising my constitutional rights to speech, and I'm video recording. That's
you and I are right on the same page. I agree with you. You being a nuisance or being rude to the police doesn't amount to a crime.
And you don't see any crowds being drawn there, do you?
Sure, you're preaching to the choir. I'm telling you that I agree and that I feel very strongly about your defense at trial, but that it's a trial defense.
Okay, but you don't...
Because the judge just denied the Franks hearing. Now the motion to suppress is limited in scope, and that's why I didn't put in all the things that you're now talking about. I agree with you, but it's not the right method to do a suppression. It would have been through a Franks hearing, which we tried and were denied.
Okay, so that if I showed that video evidence, would I be... Is there any possible way that I could be convicted on that video for anything?
In my opinion, you shouldn't be. Ultimately, it's 6 people, right? You or we pick 6 people from the community, and they're the ones that decide. I can't tell you that they are going to decide a certain thing, but if they follow the law and they look at the video, I don't believe you've committed a crime. I've viewed the video many times. So has Doug. We've both viewed it. Neither one of us think a crime has been committed.
Yeah, because, based on your expertise, you can see I'm just practicing First Amendment protected activities, and there is no crime committed. I didn't draw a crowd, I didn't use any violence, and there was no offensive conditions. So if they do convict me, let's just say that the judge has her favorite 5 sisters there, or 6 sisters, and they all hate me and they find me guilty, I would not be going to jail that day, right?
I don't believe you would go to jail that day, and I also believe that if that were to happen, you would have a number of appellate issues, that including the Franks motion being denied, leading to what should have been a suppression, and including leading that the elements of the crime haven't been committed. Same reason we laid out in the motion to dismiss. Like I said, one of them was allowed, but I think all 3 of them should have been dismissed. I think the other 2, you didn't commit the crimes.
Yeah, they were holding on to the skids, using that as probable preponderance evidence, the skids. Leaning on the camper.
What do you mean?
They said that there were skids leaning on the camper, and that was the problem. And that's why they continued it.
Yeah, but that doesn't amount to either of the 2 crimes that you're charged with. I mean, at least in my opinion.
Okay, now if let's just say hypothetically I'm found guilty, would I go to jail that day, or do I get to appeal and then it's put on hold?
Well, if you were sentenced to jail, usually they sentence you that day and you go to jail that day. I don't think you're going to jail for these crimes, even if you're convicted, is what I'm saying. First of all, I don't think you're going to be convicted. Second of all, if you are convicted, I think you'd get some sort of probationary sentence. Nobody's hurt. It's not a violent allegation. Even if you were convicted, I don't see this turning into a jail case.
Yeah, because I haven't been arrested in 18 years.
I don't think it's likely that you would go to jail if you're convicted.
And wouldn't they be in violation of Title 18 as well, because they're oppressing me for exercising constitutional protected activities?
I think you're probably right on that, but to be honest, that's not something that the jury would decide, because for them to be either charged criminally or civilly for violating your rights, you would have to either get the U.S. Attorney's Office to file criminal charges against the officers, or you could file a civil suit, but that would be a separate case. So I don't disagree with you that they violated your rights, but it's not part of the case that the jury would have to decide. They don't have to agree that they violated your rights for you to be found not guilty.
Okay.
I think you're found not guilty because the police demonstrably lied, both in the affidavit, affidavit for the search warrant and their version of events in the report compared to the video evidence we have. So I think the police credibility is shot, and I think that the elements of the crime just aren't met. That the police obviously have some sort of thing out for you.
Yeah, I have more material too as well, because I put complaints on these officers in the past.
Right. So they have a motive. They're biased. They just don't like you guys.
Yeah.
So again, look, Sean. Like I said, I respect the decision. If you want to move on your own, that's fine. I just wanted to let you know my thought process, because I think a lot gets lost in translation through the emails, and it seems that you're feeling I'm not doing what I should do, and I wanted to tell you why I'm thinking what I'm thinking. That I'm not disagreeing. It's fruitless for the motion to suppress.
Okay, I'm just very confused because I don't understand how I'm being charged for constitutional protected activities and being oppressed for all these years for something that's illegal, that's guaranteed by Congress, and I didn't even break the law.
I agree, and that's what we said in the motion to dismiss. The judge denied it, I think wrongly, and that's why we have appellate courts, because if the jury convicts, then we appeal it, and then the three appeals court judges will decide if that judge got it wrong. So I agree with you. This shouldn't even be a case. You shouldn't have been charged in the first place.
Okay, because I'm going to be suing for this because I feel very oppressed by this, that I thought I had a constitutional right to do all these things, and now I'm being charged for this and punished, and I don't think it's very fair.
You can sue them under, there's a section 1983.
Yeah, I know about that. Yeah, 42, 1983. I'm going down to the court tomorrow to file some charges for 1983, and I'm going to put a stay on it so that I don't miss my deadline.
Yeah, you can do that. And again, it's a separate case. I agree with you that this shouldn't have been charged. I'm arguing that it shouldn't have been charged. So, I don't know. That's basically all I've got. I mean, assuming you still want me to file this motion to withdraw, I'll do it, and that's fine. I just wanted to give you my perspective.
Well, I appreciate you giving me your perspective, but, I didn't have any communication, so I don't know these things, and you always told me to wait, and I don't know what's going on, so that's why I get like that, because I feel like I'm being violated. I don't know.
Well, I'm sorry I'm sorry, Sean. I really mean that. I hope your case goes well. I think it should. I'll still file. So, and if you have any things that you want to run by me, let me know. I do hope it goes well. I'd have to ask this. Would you consider taking down those bad reviews? I mean, obviously it's your protected activity, but...
Well, I was going to go do that anyways until this is resolved.
Okay. I appreciate it.
Because I'm sorry I didn't give you a chance, but I didn't know what was going on, and all I want you to do is answer my questions. My questions are important.
No, I know, Sean. And I was out for 2 weeks. I did do like 1 or 2 Zoom courts, and I mean, I was kind of, I was weak. I had COVID, so I did a little bit of stuff, but I just wasn't up to I wasn't checking all my emails and responding. And, I told everybody I was out for a couple of weeks because that was the truth. And I was doing very minimal stuff while I'm, doing a couple of Zoom courts or whatever. So,
all right.
Anyway, I guess I thank you for, considering taking the reviews down for now. And if any changes, let me know, but I'm going to file this motion to withdraw and then go from there, I guess. And if you have any questions or anything, let me know, and I'll do my best to answer them.
All right, let me just ask you one more question. I know I already asked you, but I don't have a clear answer, but let's just say hypothetically I go into trial and they find me guilty. And would I go to jail that day, or do I get a chance to appeal, and would it put a stop on it until the appeal is complete?
If you were going to be sentenced to jail, it would be that day. It would be that day for the sentence. I highly, highly doubt that you would. The sentencing guidelines don't call for jail time for these two charges that you're facing. In fact, if that's helpful to you, I could look up the guidelines and tell you what they are.
Okay, thank you.
Well, again, one, I don't think you're going to be found guilty, and two, if you are, I'd be shocked if you got jail time.
Yeah, you know that other case of harassment I was telling you about? They found me.
Yeah.
They found me responsible with no evidence at all. These people, they hate us over there. The court hates us too.
Did you go to trial on that?
No, it wasn't a trial. It was a civil for a 258E.
Oh, yeah. I remember you told me about that. You got a hearing like a couple months ago.
Yeah, no evidence. No, the lady kept contradicting herself. It was all because I had a camera on my head, and they put a 2-year restraining order on me, which I'm appealing.
Oh, I remember that you sent me the video of that. You were like in a store with, I think, your son and daughter or something.
Yeah.
That was ridiculous. Like,
yeah, that's what I'm saying.
I thought. Well, but that's the judge, though. I think you're getting the judge that's unfair too. That's why I'd say if you go to trial, if it were my choice, I would say do a jury trial, because at least you have a chance to question the jurors before and try to. Yeah,
but they're gonna hate me when they see that video. But
yeah, but the way that I would approach it is, look, you can say, look, if maybe I was rude during this confrontation, I was upset that the police were treating me, they were violating my rights, but I didn't commit a crime. I mean, at the end of the day, you didn't commit a crime. They don't have to like what you say, but that's why we're protected activities by the Constitution. It's the most important rights that we have as American citizens, is the Constitution. It's guaranteed.
Yeah.
So you saying something they disagree with, it's a slippery slope. If they don't like what you say today, what if they disagree with your politics? What if they disagree with your religion? What if it's a slippery slope. That's why it's guaranteed. That's why it's so important that you get to have free speech.
Okay, and I just got one more question for you. I know it's probably not relevant, but my son is being charged with an assault for supposedly running at the officer. He's never been arrested in his life. His whole life is being ruined. Do you think there's a chance that he could go to jail for that, considering it's his first offense? He's never been arrested or anything?
Probably not. Was there any? Are they claiming there was any injuries or anything, or just?
No, because he ran at the officer and scared him. He wasn't even arrested. He was charged 4 days later.
No, I doubt it. I mean, I really doubt it.
I mean, they didn't even arrest him when he went to the police station with his camera afterwards. He was down there for hours swearing at the cop and yelling at him, and they didn't arrest him.
Yeah, I doubt it. I saw that. I saw at least some of the videos that he was there and saying, my phone, when's my dad coming out?
Wouldn't he be arrested if he assaulted an officer? Do you think they would really let him do all that?
No, of course not. He would be in handcuffs.
Yeah. He didn't even get touched. See how evil this is? See how corrupt this is?
I understand. I completely agree with you. You really shouldn't have even been charged.
Yeah, you're going to see the whole complete story of the whole conspiracy. It started in 2018. You're going to see it on YouTube when this is over. You're going to see the whole story.
Okay, I'll look at it. By the way, just since as I'm looking right now, there's a sentencing guidelines grid, and right now, where you are charged with two crimes, at least in our case. One is disorderly conduct, and I'm just looking at this right now. Disorderly conduct is a level 1 crime, like according to the table that they have. I'll email it to you so you have it.
Okay.
But the sentencing guidelines call for a probationary period. It doesn't even call for any jail time. Even though it's a possibility for the statute, the guidelines that the judge looks at, there's nothing, there's no jail time recommended. And then, disturbing the peace. Let me just see if I can find that one real quick. Disturbing. Just so I can give you, let's see, disturbing the peace, that's also subsequent offense, that's also a level 1. And that is also suggested probation.
And what do you think
So the
about
judge
my son?
would have to be extreme. To sentence you to jail, the judge would have to go way above the guidelines. You're 2 levels away, because even level 2 calls for probation. So you're 2 levels away from a judge giving you any sort of jail time. He would have to be egregious to give you jail time on this case now that we've gotten the resisting arrest gone.
And what do you think about my son, considering he has no record and he's never been arrested?
Same thing. I don't think so. I don't think he's going to go to jail.
Is he on a level 1 too?
Well, let me look. Hold on.
I appreciate it.
Yeah, no problem. Resisting arrest. Wait, no, I'm sorry. What was his crime again? It was assault.
It was assault on an officer.
Okay.
He didn't even touch him either. It wasn't a battery. It was just, he put him in fear because he ran towards him, which we have on video, which is also another lie.
All right. Well, it's a big guideline. I'll send it to you so you have it. But
Okay.
Regular assault is it's a level 2, but that's also presumptively, if you have no or a minor record, it's probation. So I don't know. I have to double check and see if the assault on police is any different, but I'm not seeing a separate assault with a police officer, at least as I'm looking right now. There's assault and battery on a police officer.
No.
That's obviously that would be a level 3 where there's a potential for jail time, but he didn't batter. It's just assault. So I think it falls in the same as regular assault.
So it's pretty much impossible for us to go to jail even if we're convicted at trial?
It would be very surprising based on the guidelines. I'll send them to you. Then you'll see it for yourself. But
Okay, thank you. I greatly appreciate that, and I'll get back to you later.
okay. All right. Thank you, Sean. I will email this to you, and then I'll submit the motion. But I do hope it goes well. And if you have questions, let me know.
Okay, well, if you want to still represent me, let me think about that, all right? And get back to you later?
Okay. Can you let me know today then?
Yes, I can.
Later today?
Yes, I can.
Okay. All right.
That's all I wanted was some answers, sir. Thank you.
Okay. You're welcome.
All right, bye.